Good day, Crime Talk aficionados. We have a big show for you today. Why? Because there's a lot of stuff going on and we got a lot of trials. First, the Leilani Simon trial finally begins. Jury selection begins in the Delphi homicide case. There's some death penalty litigation taking place in Idaho that didn't take place on the last two death penalty cases in Idaho. The Sarah Boone jury selection is underway in Florida. The Cash App founder murder trial begins in California. And the attorney for the now former sheriff, Shawn Stines, he speaks. We got Gypsy Rose giving advice to the Menendez brothers. We have the This Day in Legal History segment. And then finally, our dumb criminal of the day. And it could be added to the You Can't Make This Stuff Up file. Let's talk about it.
Hi, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And remember, you can check us out on any of your favorite podcasting apps. All right, before we get to the docket, that's right, CrimeTalkSearch.com. Easy to remember, easy to find. Go to that website. Hit the link, sign up for that background subscription service today. When you do sign up, you can do as many background searches that you desire on anyone here in the United States. And you're going to get all kinds of information that maybe people that are coming into your life that are new aren't necessarily going to talk to you up front about it. Do they have a criminal history? Are they married? Are they divorced? Why do they have 10 emails? Are all different names? All those types of things are things that you're going to find out. If somebody's coming into your life, you need to check them out. Go to CrimeTalkSearch.com. You're going to be happy you did. And remember, yes, there's a small fee, but everything in life you have to pay for. And the reality of it is, guess what? You can cancel at any time. All right, let's go ahead and get to the docket today, October 14th, 2024. So, first thing on the docket is the Leilani Simon trial begins. That's right. The mom accused of murdering her toddler and dumping his body in a dumpster told police she was throwing out spoiled shrimp pasta when police confronted her about driving to a mobile home park to take out the garbage at 1 a.m. in the morning. So Leilani Simon is standing trial in Georgia on charges of malice murder, felony murder, concealment of death, and making false statements to police following the death of her 20-month-old son, Quentin, way back in October of 2022. This just seems like it took so long to finally get to trial. Anyway, Leilani is accused of beating her son to death and dumping him in the trash, and his little body was found in a landfill a month after he was reportedly missing. Now, like I said, the trial is underway. Now, the district attorney who's prosecuting the case has played footage of one of her interviews in the day after Quentin's disappearance, in which police asked her why she traveled to a secluded dumpster at 1 a.m. in the morning when her son had vanished. She said, "I did throw away trash. There was, some spoiled food and it was smelling up my car. So when I pulled around and saw that I stopped and threw away the trash, it was spoiled shrimp pasta. The whole car kind of smelled like shrimp. I was like, what is that smell? I looked and I threw it away. I didn't think anything of it, to be honest with you. It's just old food." That's right, throwing away a small child like it's just garbage. Anyway, police allege that Simon had met with a drug dealer shortly before the murder and that she traveled to a mobile home plaza, which was in a secluded area and had a series of dumpsters lining the street. She throws away Quentin's body like a little piece of trash in the morning, the prosecutor alleged. Now, the prosecutor mentioned in opening that the defendant violated the most basic sacred trust of any parent in the most horrible way. In the middle of the night, she killed him, her own son, got in her car with his body, drove him to a dumpster, then threw him away like a piece of garbage. She would go home, go to sleep like everything was normal, wake up in the morning and report it to the police. Those dumpsters were picked up by garbage truck and taken to a landfill the same day Quentin's body was allegedly dumped. She told police her son was abducted by an intruder who broke into her home, but the Chatham County Police chief suspected of her of wrongdoing from the beginning. Now, Simon was seen at the trial shortly after it got underway. She had her heads in her hand, and she was actually crying at times. The prosecutor then shared footage of Simon months before the alleged crime to offer the jury an insight into the mother of three state of mind. He described the footage showing a hysterical and sobbing Simon driving toward a river and implying that she would end her life as a digital suicide note. Now, in the distressing clip, Simon described her youngster. In the disturbing clip, Simon described her youngest child, Sky, as a beautiful little girl. I wish I could watch you grow up. I wish I could hold you for your first heartbreak because my mama didn't. Sky, I love you, little baby girl. She then referenced her eldest son, Zane, telling him, you are so handsome, so sweet, so protective. You are going to be such a good man one day. I hope you grow up and learn what loyalty is, and you learn how to treat a woman, how to love a woman. Then, directed to Quentin, she said, you are a middle child. You are so happy all the time. Smile all the time. Simon then turned her attention to her on-again, off-again boyfriend, Daniel Youngkin. Danny, I love you, she said. I worship the ground you walked on. I would do anything for you, even when I was carrying your child and hating myself every day because you did not want to have sex with me. You did not want to love me. You just did not want me. I wanted you more than life itself, she said, but you have proven it was the only way, that feelings, that love, that loyalty, it was all one way. I'm at the river now. Bye, Danny. Well, Quentin was last seen alive on October 5th by Simon's boyfriend, Daniel Youngkin, who saw him at a pack and play at 6 a.m. 3 hours later, Leilani reported Quentin missing from her home. She claimed to have woken up about 9:30 and found the door to the house open with her son gone. Simon's two children were removed from her custody a week after Quentin was reported missing, and Simon was ultimately arrested on November 21st, just days after police found Quentin's remains in a Savannah, Georgia landfill. It's going to be an interesting trial, ladies and gentlemen. Not really a whodunit. Doesn't look good for Simon, but we got to go through the process. We must go through the process, give her a fair trial, and more than likely she is going to be convicted. Next, the Delphi Murder Trial jury selection begins. Jury selection in the case of Richard Allen, highly anticipated trial. And as you know, Richard Allen is accused of murdering the Delphi teenagers, Libby German and Abigail Williams. And that, like I said, the jury selection is beginning today. Now, this is 2 years after Richard Allen was arrested and charged with the girls' double murder, which has been characterized by a string of chaotic developments. It's finally getting to trial. But in their attempt to make sure that Mr. Allen's jury pool is not biased, given the intense local feelings and a lot of publicity around this case, juries will be selected not from Carroll County, in which the small town of Delphi, Indiana, sits, but from Allen County, which is about 100 miles away from Delphi. Now, concerns that an appeal recently filed by Mr. Allen might derail the start of the trial, which is slated to begin back in Carroll County Courthouse in Delphi on Thursday, well, those concerns were quashed when Allen County Special Judge Francis C. Gull, who is presiding over the case, denied that request to do an appeal. So it was the second hit that the defense has taken as many months. Last month, the judge ruled the jury could not hear the defense theory of alternate suspect and set forth across hundreds of pages of legal filings that the girls were the victims not of Allen, but of an Odinist cult, and this was a ritualistic killing. Judge Francis Seagull decided to exclude that theory when it was aired in an earlier court hearing on the grounds that the theory had no evidence to support it, and it would simply confuse the jury. It has been 7 years since Libby, who was only 14, and Abby, who was 13 at the time, set out on the hike along the Delphi Historic Trail from which they would never return, and the small Indiana town became forever synonymous with the friend's horrific murder. Now, the search for the girls began after they failed to show up to meet family on the afternoon of February 13th of 2017. And earlier that day, Libby had taken what would turn out to be the last picture of Abby. She posted the image of her friend standing at the trail's abandoned Monon High Bridge on Snapchat. The girls' bodies were found in a woodland area the following day. Investigators have said little about the circumstances about the death, other than they said there was a lot of blood. But it was since emerged that the girls were both killed with a knife and a box cutter type instrument, undressed, and their bodies staged and covered in branches in a fashion that gave birth to the Odinist cult theory. Now, back on February 15th of 2017, 2 days after the murder, police released what will be known as the defining and chilling image in the case. The grainy screenshot taken from the video retrieved from Libby's cell phone showed a man who would become known as the Bridge Guy, filmed by the teenager in her final moments of life. Now, she was dressed in jeans, a blue jacket, and a cap. He was seen walking on the bridge on which, moments earlier, Abby had posed for the picture. He walked with his head down and instructed the girls down the hill. One of the teens could be heard saying, "Gun," as he approached. Now, among the evidence leveled against Allen is that the bullet found near the girl's body had been cycled through a gun that was owned by Allen. But despite the police receiving thousands of tips and true crime fanatics kind of poring over the short clip and analyzing the audio, in a bid to identify the Bridge Guy, the case basically went unsolved. Now, the girls' families, particularly Libby's parents, pushed the case to make sure it was kept in the public eye, regularly speaking at press conferences and even attending CrimeCon. Now, in the intervening years, in the following years, seemingly significant developments led nowhere. First, we had the while Keegan Kline of Peru, Indiana, admitted to police that he had solicited hundreds of nude pictures from teens by catfishing them, posing as a teenage girl by the name of Emily Ann, or hunky actor model Anthony Schatz. It emerged that Kline, who has since been sentenced to 43 years in prison for a slew of child pornography charges, had communicated with Libby under the assumed identity of Schatz. He was one of the last people to message the girl before they took their final hike. But police interviewed him. They told Kline they did not believe he had committed the murders, but that he might be protecting someone who actually did commit the crime. Earlier in the investigation, the police had identified Ron Logan, on whose property the girls' bodies were found, as a possible suspect. As FBI search warrant was served on Logan's home and property back in March of 2017, it revealed that on March 14th, the day after the killings and before the bodies were found, Logan asked a relative to provide him a false alibi. He told a cousin to say that the friend had picked him up and taken him to a fish store between 2 p.m. and 2:30, and that he didn't return home until about 5:30 p.m. The last time the girls were known to be alive was about 2:13 in the afternoon, when Libby made her brief cell phone recording of the Bridge Guy approaching the two young girls. Now, Logan's alibi was shown to be a lie, and text messages retrieved from his phone showed that he was out of his house and in the vicinity of the murders on the evenings of February 13th. Now, the FBI documents also noted that Logan, who had a history of violence against women, asked his relative to lie for him following the morning before the crimes were even discovered. Yet despite this, and despite the former girlfriend stating their belief that he was involved, Logan was never officially named as a suspect and died at the age of 84 in January of 2022. 10 months later, when police announced that they had arrested a local man and charged him with the murder on October 31st of 2022, the news seemed to come out of nowhere. Allen was a married guy who has a 30-year-old daughter, not only lived in Delphi, a town which has only 3,000 residents, he worked at a local pharmacy. In fact, it was discovered that Allen had been interviewed by police immediately after the killings back in 2017, but somehow that interview had been overlooked or lost or misfiled by the FBI contractor, and only came to light when the new investigator went back and looked at everything in the case file and realized that this interview had been misfiled. Anyway, in an interview with Allen, he admitted to the officers who met with him that day that he had been on the trail that day, during the period the girls disappeared and was wearing clothes considered to be consistent with bridge guy. And according to the arrest warrant unsealed by a judge back in December of 2022, several other witnesses told officers that they had seen a man in similar clothing, and one woman told them she saw a muddy and bloody man about 4 p.m. walking away from the area where the girls' bodies were later found and towards the area where Allen had allegedly parked his car. In the months since, though, prosecutors have shared a few details about the crime. The girls' autopsy reports have been withheld. It is not known if they were sexually assaulted and if the crime was opportunistic or planned, or if the girls were specifically targeted. Now, the Carroll County prosecutor, Nick McClellan, argued for multiple court documents to remain sealed back in 2022 on the grounds that there is good reason to believe that Allen is not the only one involved. Well, despite these issues and that statement 2 years ago, there have been no further arrests in connection with the crime that took place back in March of 2023. Now, despite issuing that statement 2 years ago, there have been no further arrests in connection with the crime. And then back in March of 2023, Allen is said to have confessed to a prison psychologist by the name of Dr. Monica Walla. Now, shortly after his arrest, Allen was transferred from the Carroll County Jail to Westerville Correctional Facility, about 76 miles away, where he was held in an isolated cell for his own safety. It was there that Dr. Walla told the court at a hearing during which the defense attempted to have the testimony excluded moment. He had a come-to-God moment and confessed. Allen, who his attorneys argued has been showing signs of grave mental illness, also confessed more than 60 times during recorded telephone calls to his wife and his mother. Now, according to the Indiana State Police detective, a guy by the name of Brian Harshman, Allen gave specific details about the crime and what he claimed was his motive. Now, according to the Indiana State Police detective, Brian Harshman, Allen gave specific details about the crimes and what he claimed was his motive. And just this week, Allen's wife, Kathy, gave a lengthy statement to a podcast through her attorney in which she addressed her husband's confessions and rumors that have suggested that she no longer believes in her husband's innocence. She admitted that their marriage has been profoundly affected by Allen's incarceration and said that both are suffering immense distress. But she insisted that she loves her husband, she believes in the sanctity of marriage and those marriage vows, and believes that the same presumption of innocence our legal system gives to Rick should be given in equal measure to her husband as well. The attorney stated, as to her husband's alleged confessions, it's not true that Cassie now believes them. The attorney also noted, with malice toward no one, Kathy prays for justice and for healing for all the innocent people affected by the murders of Libby and Abby. And she is also extremely grateful to Rick's defense team and lawyers, their staff, and investigators. Now, Allen came close to losing his defense team, as you may recall, following a leak of some crime scene photographs in which the office was implicated. Judge Gull told them to withdraw or that she would strike them from the case. Well, they did, but then they didn't after the Indiana Supreme Court reversed that decision, and Allen expressed the desire to maintain his original legal team. And they have given up a good fight. I think a lot of it should have been saved for trial and not been filed in pretrial motions, whereby the prosecutor was allowed to raise motions in limine, basically keeping out their alternate theory of defense. Now, a lot of it's still going to come in. Clearly, probably was not just Richard Allen doing this on his own. But, if they only charge one person and there's more out there, it doesn't mean he still can't be convicted. These confessions, problematic. The defense has a tough road to hoe on this one, ladies and gentlemen. If it's on recordings of him confessing to the psychiatrist, him confessing to his wife on the phone, as well as confessions made to other people who were basically there to monitor what was being said from him while he was in this cell, those are going to be tough. People usually don't confess to things they didn't do. Now, is it possible a false confession? Yes, but 60 times starts getting a little tougher. Next, we got some real death penalty litigation taking place in Idaho, something we haven't seen on the last two death penalty cases that we saw in the Lori Vallow case. In the Lori Vallow case, as well as the Chad Daybell matter. Obviously, both of those cases became death penalty cases. Lori Vallow got the death penalty enhancement charges taken off of the table or for consideration because the prosecutors failed to turn over discovery. Chad Daybell waived his right to speedy trial and gave his defense attorney time to prepare. But there really wasn't a whole lot of motions practice as it relates to the death penalty. Well, that's not the case in the Kohberger matter. Now, in death penalty litigation, normally you're attacking everything, and we'll talk about them in a second. What's taking place, but that's the heart of the death penalty litigation. A lot of constitutional issues. It's cruel and unusual punishment, societal standards. That's the crux of it. We didn't see that in the previous cases, but the prosecutors have had to respond to the death penalty motions filed on behalf of Brian Kohberger. And needless to say, the prosecutors are asking the judge to reject the arguments from Kohberger's defense team, asking for the ruling that the death penalty in this quadruple murder, and to shut down the request to exclude an outside expert to testify on the constitutional issues regarding the capital punishment. Kohberger's defense team, led by Ann Taylor and Elizabeth Mathis, made numerous requests outside the boundaries of established precedent, prosecutors wrote in their response this week. Now, the Kohberger's lawyers also argued that the state has no viable method to conduct execution and that there has not been enough time to adequately prepare the case against him. Now, the thrust of the defendant's argument is that the applicable aggravating factors in a capital case must be presented to a grand jury, what the defense attorneys are arguing. But the attorneys on the prosecution side disagree. They say in their arguments that their arguments squarely foreclosed by binding Idaho Supreme Court precedent. They wrote that they met their own legal obligation by including a probable cause affidavit in the superseding indictment and by notifying the defense that the state planned to seek the death penalty within 60 days of his arraignment when a judge entered a not guilty plea on his behalf. Now, under the law, they added, they were not required to include additional probable cause for each aggravating circumstance that led them to seek the capital punishment. They also rejected Kohberger's argument under the Eighth Amendment that the death penalty could be cruel and unusual punishment if the prosecutors seek it without consulting a neutral fact finder. The prosecutors also asked the judge to reject the defense request for expert testimony against the death penalty option in a separate filing. They argue that it is very well established in Idaho that testimony containing conclusions of law by an expert witness is generally inadmissible pursuant to Idaho case law, because the expert witness would then offer a legal conclusion and it invades the province of the court to determine the applicable law. Last month, the defense filed their motions attacking the possibility of the death penalty on numerous grounds, ranging from contemporary standards of decency, evolving standards of decency, where maybe it wouldn't be, community wouldn't want the death penalty. And the defense claimed that Idaho's two legal methods of execution, legal injection and firing squad, violate both the Eighth Amendment, and only 26 people have been executed in Idaho since the state introduced capital punishment back in 1864. The death penalty is now carried out by lethal injection, and the state legislature passed a law in 2023 that allows firing squad if lethal injection drugs are not available. Now, although the prosecutors have previously said they want the death penalty, their latest filing is in response to the defense request that the death penalty be ruled out. Now, there were a total of 13 briefs submitted last Friday, and the prosecution rejected all the claims that the public did not favor the death penalty. And the 14th Amendment, they asserted that the firing squad was never constitutional. Now, the crux of the defendant's arguments is that there has been a major shift in public opinion regarding the morality, decency, and the humanity of the death penalty. The prosecutors, however, pointed out the majority of the United States have the death penalty despite defense claims that it was somehow out of step with modern social norms. So let's unpack this. These are all going to be denied. These motions are all going to be denied. The death penalty in Idaho is not going to go away unless the voters of the legislature take it away. The United States Supreme Court has said that basically this is an issue for the states, but that the death penalty is not cruel and unusual punishment. And even when somebody is in fact executed, the Supreme Court said, hey, you're entitled to, death, but it doesn't have to be completely painless, because there was an example, I believe, in Mississippi where there was concerns that the drugs didn't work, or, the Supreme Court said, no, it doesn't have to be completely painless. All right. And the issue that they're trying to make, and this is what the defense has raised from the beginning, is when Bryan Kohber was indicted, he was indicted on the burglary count and then the 4 counts of murder, so 5 counts total. What the defense is saying is that there's a United States Supreme Court case that says that if you have certain enhancements and penalties, things that would increase the penalty, that has to be basically pled, proven beyond a reasonable doubt to a jury. It's called the Apprende case, all right? So, for example, if somebody committed a crime and they used a gun, you have to plead that there was a gun. So the defense is saying, hey, all those aggravators, you should have pled those in the indictment. And since that you failed to plead those in the indictment, you shouldn't be entitled to present them to the jury as aggravating factors, and hence no death penalty. I think the court will reject that. Now, will it make for decades and decades worth of litigation at higher courts? Yes, it will. But that's what death penalty litigation is supposed to do. The ultimate goal is to delay. That's just reality, ladies and gentlemen, and usually it works until 20, 30 years later, when just about everybody that's involved with the case has since passed, and they will go forever. We'll see how it works out here. My prediction is denied. Next, the murder trial of Sarah Boone begins. That's right. Jury selection is underway for the woman accused of murdering her longtime boyfriend by putting him inside a suitcase and leaving him to die in there. Now, jury selection was originally set to begin on October 7th, but there was that little hurricane last week, and that prompted the courthouse to close and postpone the proceedings to today, October 14th. As I noted, Sarah Boone is charged with second-degree murder in the death of Jorge Torres Jr., her boyfriend, who was found inside a suitcase that the couple shared an apartment at back in February of 2020. Now, in a series of interviews at the scene and the next day at the sheriff's department, Ms. Boone told investigators that Mr. Torres was put in the suitcase willingly, and then the couple were playing a game of hide and seek after a night of drinking, because that's normal, right? Anyway, prosecutors say key evidence in the case includes 2 videos found on Boone's phone where she recorded Mr. Torres was in the suitcase, and the video features the victim begging Miss Boone to let him out. But Miss Boone was caught laughing and taunting him. Now, Boone told the police she went to bed shortly after the videos were taken and ultimately just fell asleep, leaving Mr. Torres in the suitcase. Now, Ms. Boone is represented at trial by attorney number 9, James Owen. He volunteered to step in as the lawyer after the judge ruled that she had forfeited her right to an attorney as a result of her unwillingness to basically get along and cooperate with her 8 previous attorneys. So it was Boone's poor behavior that raised the issue. Anyway, Ms. Boone has been very vocal about her defense, writing a number of letters to the judge, and even created an advertisement looking for a lawyer. That got Mr. Owen's attention. He filed an intent to use the battered spouse syndrome as a defense in the case, citing years of domestic abuse and arrests of Mr. Boone and arrests in Owens had filed a notice of intent to use the battered spouse syndrome as a defense in the case, citing years of domestic abuse by Mr. Torres against Ms. Boone. And then on October 7th, Boone rejected a plea offer from the prosecutor that would have sent her to prison for 15 years for pleading guilty to manslaughter. If she's found guilty, she faces a minimum of 22.5 years in prison and a potential life sentence. Now, just when you thought there couldn't be any more high-profile cases being heard this week, guess what? We've got more. The murder trial of a tech consultant in the stabbing death of the Cash App founder Bob Lee begins today, a year and a half after the entrepreneur was found staggering on a deserted downtown San Francisco street, seeking help from anyone who could hear his cries. Anyways, Lee's death stunned the tech community, and fellow executives and engineers all wrote tributes to his generosity and brilliance. Now, Lee was the chief product officer of cryptocurrency platform Mobile Coin when he died, and he was the father of 2 children. Now, prosecutors say that Nima Momeni planned the April 4th attack after a dispute over his younger sister, Kazar, with whom Lee was friends. They say that Momeni took a knife from his sister's condo, drove Lee to a scheduled area, and stabbed him 3 times and then fled the scene. Now, needless to say, the defense attorneys disagree, and they say that Lee was high on drugs and attacked Momeni. Our theory is that Bob had the knife and that Nima attacked in self-defense, according to the attorneys. He said his client is eager to tell his side of the story, but they haven't decided whether he will testify in his own defense. Momeni, who lives in nearby Emeryville, California, has been in custody since the arrest after Lee died at a San Francisco hospital. Prosecutors have said in court documents that a friend of Lee's told homicide investigators they had been drinking with Momeni's sister the day before the stabbing. The friend said that Momeni later questioned Lee about whether his sister was doing drugs or otherwise engaging in inappropriate conduct, and Lee said that she was not. Well, surveillance video of Lee's final night shows him entering the posh Millennium Tower downtown, where Momeni's sister lives, with her husband, a prominent San Francisco plastic surgeon. Video then shows Lee and Momeni leaving the building together at about 2 a.m. and driving off in Momeni's car. Lee was found about 2:30 a.m. in the Rincon Hill neighborhood of San Francisco, which has tech's offices and condominiums, but little activity in the early morning hours. Police ultimately recovered a knife with a 4-inch blade at the scene. Prosecutors said they tested it, and it had Momeni's DNA on the weapon handle and Lee's DNA on the bloody blade. But the defense said police should have tested the handle for fingerprints. Well, Momeni has pled not guilty. Obviously, we'll give him the presumption of innocence, but he is facing 26 years to life in prison if convicted. The trial could go until mid-December. Not sure why it's going to take that long. It seems like it would be a week-long trial just about anywhere else. All right, the attorney for Sheriff Mickey Stines speaks. So it's a case many in the Commonwealth of Kentucky have been following since the very beginning, not only there, but across the country. When Letcher County Sheriff Shawn Mickey Stines allegedly killed District Court Judge Kevin Mullins back on September 19th of this year. And a 27-second video shows the brutal shootings of Judge Mullins. However, the defense attorney for Stines, a guy named Jeremy Bartley, said those 27 seconds lack the full story. He says, quote, "I think that we need to see the entire video and the other evidence that can put that into context. And without that context, that portion we saw does not stand alone. There has to be an understanding of the full story," he says. And at this point, we don't have the full story. Now, he's referring to us because apparently he does. Now, he could just tell us the full story, but he's choosing not to. Anyway, the attorney has said that the fatal shooting wasn't planned. He said, quote, "I specifically asked the officer if there was any indication in his investigation that this was in any way planned, and he indicated that at no time was it planned at the preliminary hearing, and he believes the highest level of culpability should only be manslaughter, and that's what he is asking the grand jury to return charges on if they decide to indict." And he's saying that we're saying that based upon the facts that we know so far, that there should be a ceiling. But they're going to mount a full defense, and extreme emotional disturbance is a partial defense. It's called heat of passion, where I come from, ladies and gentlemen. We discussed it last week. Go check it out. But they intend to pair that with several other defenses. I don't remember seeing any attacks there, so I don't think it's going to be self-defense. Heat of passion. Anyway, since this incident, a lot of questions have been raised about and a lot of confusion at the time of the preliminary hearing as to whether Stein's daughter's phone number was saved as a contact in the judge's phone. The attorney says, quote, "My question when I asked was the number on the phone?" And he was referencing a recent call. I didn't specifically ask if it was a contact. If they say it's not, then I'll take that at face value. Another pressing question was whether the federal lawsuit where Stine was accused of failing to investigate allegations that one of his deputies repeatedly sexually abused a woman in Mullins Chambers was a reason for the crime. One must wonder if they were not related, but again, we wait to see the evidence and the completion of the state's investigation and completion of an independent investigation. That's what the attorney says. Well, he knows. Why doesn't he just tell us? Obviously, he says he's hoping for an acquittal, and he says they're going to put on this full defense, an urge for an acquittal, and if this case goes in front of a jury, that's what they're going to ask for. Of course they will. Anyway, he says he's not going to announce today what he believes the defense will be, although everyone wants to know, obviously. Listen, it's got to be heat of passion, ladies and gentlemen. We'll talk about it in a second. Anyway, the Letcher County grand jury will review this case, and they'll determine what charges and the level in which the grand jury believes that they should be indicted. Listen, we've seen the video. Yes, there's 27 seconds, ladies and gentlemen. Listen, I'm dying to know. Like we all are. We're dying to know, was there something inappropriate going on? Was the judge a hero or weird, creepy guy, right? Was the sheriff a hero or weird, creepy guy? We won't know until somebody actually presents this evidence in court, subject to cross-examination. Can we really take it as that's what took place? That's going to be the issue. But the video itself, I can make an argument all day for first-degree murder. How long does it take to deliberate that you're going to kill somebody? He is a sheriff. He knew what he was doing, right? I think there were 8 shots fired, 8 shots. Boom, 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 right? Ladies and gentlemen, how many times does it take to deliberate after deliberation? Think about this example. I've used it. I've seen it used. Pretty straightforward. How long does it take for after deliberation? It's not like you plan this months in advance or even days in advance. After deliberation, think about it. You're driving your car. You're driving down the road. As you're getting close to that intersection, you're thinking to yourself, what's going to happen? What's going to happen? Is the light going to turn yellow? Is it going to stay? Is it going to go to red? Is it going to stay green? And anyways, you're driving right up there. It changes from green to yellow, and you make that instantaneous decision of whether you stop and brake, don't go through the intersection, or you punch it and go forward. How long did that take? Seconds, right? After deliberation, ladies and gentlemen. That video of Judge Stines clearly shows after deliberation. Now, can he argue for heat of passion? Because there was something there that so inflamed the passions that it would overwhelm a reasonable person and he would react that way. Reasonable person, not a sheriff. I don't know. That's what we got to know. What was the nature of the call? The sheriff's got a tough case on his hands here, ladies and gentlemen. And don't get me wrong, I want to know, and maybe my opinion will change. But as of right now, he's got a tough case. And I think the grand jury is going to come back with more than just manslaughter. I think they'll come back with first-degree murder after deliberation. But if the grand jury hears something inappropriate by the judge, then maybe manslaughter. That's it. But I'm thinking first-degree murder. Next on the docket, can you believe that Gypsy Rose is giving advice to the Menendez brothers? What is the world coming to? That's right. Gypsy Rose Blanchard is weighing in on the Menendez brothers' case. Now, she spoke to reporters Sunday and said that she shared some advice for Eric and Lyle Menendez, who may be finally getting out of prison after almost 30 years in prison for killing their parents. She said, quote, "It's very difficult to come out to the world that has changed so much, even in the time that she spent in prison," she said. Now, she served 7 years on a 10-year sentence for killing her mother, Claudine Dee Dee Blanchard. Now, reacclimating is the difficult thing that she notes, and she would say, take your time, adjust properly, get therapy because you need it in this kind of world in this day and age, she said. Now, like I said, back in 2016, Gypsy Rose Blanchard pled guilty to second-degree murder and was sentenced to 10 years, and she got out in December of 2023. Now, her ex-boyfriend, Nicholas Godejohn, who actually stabbed her mom to death in Springfield, Missouri, back in 2025, well, he's still in prison. Now, Dee Dee had Munchausen by proxy syndrome and described Gypsy and subjected Gypsy to years of child abuse. Now, after getting out of the prison, Gypsy was thrust into the spotlight as her documentary, The Prison Confession of Gypsy Rose Blanchard and Gypsy Rose, Life After Lockup, both aired on the Lifetime channel. Well, back in July, she announced that she is pregnant with her first child with her boyfriend, Ken Urker. The couple rekindled their romance after Blanchard split from her husband, Ryan Anderson, 3 months after she got out of prison. Anyway, the Menendez brothers, meanwhile, like I said, murdered their parents, Jose and Kitty Menendez, back in 1989, and they were sentenced to life in prison without the possibility of parole back in 1996. Now, it was argued at their trial that they were sexually abused by their parents, and so they basically had to kill them out of self-defense. The jury didn't buy it and found them guilty. Now, following the Netflix show titled Monsters, the Lyle and Eric Menendez story, the Los Angeles County District Attorney, George Gascon, announced that the new evidence of sexual abuse against the brothers is being reviewed. Now, a court hearing is set for late November, which could lead to the brothers being retried or even released from prison. Now, jumping back to old Gypsy Rose, she stated that while she's not really educated on the case, she supports the Menendez brothers getting out of prison. And when the reporters let her know that Kim Kardashian is advocating for the Menendez brothers, she said, quote, "Kim is a wise woman. She makes good decisions in her prison reform era." And she said she had nothing bad to say about the reality star. Kim Kardashian, certainly successful. Hung out with old P. Diddy there for a while. Not saying she did anything wrong, but maybe doesn't have the best judgment after all. Anyway, Kardashian did visit with Eric and Lyle Menendez in jail, and she wrote an essay back in October and said that she hopes the brothers' life sentences would be reconsidered. She doesn't believe that spending their entire natural lives incarcerated was the right punishment for this complex case. And had the crime been committed today, she doesn't believe that it would be the same outcome. Yes, it would. Yes, it would. Yes, it would. Listen, they had one of the best attorneys at the time. They gave it their best shot. Jury didn't buy it. It was too premeditated. Next on the docket, this day in legal history. On October 14th, 1949, the significant event was the Smith Act trials reached a verdict. 11 leaders of the Communist Party were convicted of conspiring to advocate the overthrow of the United States government, and under the Smith Act, which was passed in 1940, it made it illegal to advocate or teach the violent overthrow of the government. Now, these convictions highlighted tensions during the early stages of the Cold War, contributing to the fear of communism that defined much of the U.S. domestic policy during that period. And these trials also led to significant First Amendment debates over free speech and the limits of political expression. It's tough to ban ideas, ladies and gentlemen, but when you're plotting to overthrow the government, yeah, that could be a problem. That could be a problem. But that's what communists do. They're always trying to destroy things and overthrow good things to replace it with bad. It's called communism. Just a little commentary there, ladies and gentlemen. What can I say? I grew up during the Cold War. All right? Communism, bad. Next, on October 14th, 1912, before a campaign speech in Milwaukee, Wisconsin, the then presidential candidate, Theodore Roosevelt, is shot in close range by a saloon keeper by the name of John Schrank while greeting the public in front of the Gilpatrick Hotel. Schrank's .32 caliber bullet aimed directly at Roosevelt's heart failed to mortally wound the former president because its force was slowed by a glass case and a bundle of manuscripts in the breast pocket of Roosevelt's heavy coat. A manuscript containing Roosevelt's evening speech was in there, and needless to say, Schrank was immediately detained and reportedly offered as his motive that any man looking for a third term ought to be shot. Well, Roosevelt, who suffered only a flesh wound from the attack, went on to deliver that speech with the bullet still in his body. And after completing his speech, the former Rough Rider pulled the torn and blood-stained manuscript from his breast pocket and declared, "You see it? It takes more than one bullet to kill a bull moose." He spoke for nearly an hour and then was taken to the hospital. Now, to fight his campaign, Roosevelt, who served as the 26th president of the United States from 1901 to 1909, was defeated by Democrat Woodrow Wilson in November. The guy that did the shooting, that Schrank guy, he was deemed insane and committed to a mental hospital where he died in 1943. And finally, on the docket today, our dumb criminal of the day. Can't make this stuff up, ladies and gentlemen. First, after pulling over suspects for driving a stolen car, Oregon police found a large drug stash inside a bag with, wait for it, definitely not a bag full of drugs printed on the outside of it. That's right. So Wednesday morning, a Portland police officer ran the plate on a 1994 Ford Taurus. It came back stolen. The officer subsequently stopped and arrested the driver, a guy by the name of Reginald Reynolds, and his passenger, Mia Baxtonis. Reynolds, cops say, was carrying a loaded .357 handgun in his pocket, a bag of methamphetamine, and roughly $1,300 in cash. The passenger had 3 white pills she said were oxy, as well as a meth pipe. You be the judge of that, ladies and gentlemen. Anyway, at 1:15 a.m., the vehicle was searched, yielded more meth, 2 scales, drug paraphernalia, and baggies commonly used for selling drugs. And as the investigators noted, a brown bag that said, quote, "Definitely not a bag full of drugs," end quote. Inside the "definitely not a bag full of drugs," cops found multiple packages of what officers recognized through their training and experience as methamphetamine. And it all tested positive as well. Anyway, in total, the police seized half a pound of meth, ladies and gentlemen. Well, Mr. Reynolds and his passenger were charged with an assortment, a sundry of felony charges, including possession of a stolen vehicle and methamphetamine possession with intent to distribute. Well, the definitely not a bag full of drug bag is now in the possession of the police. And police thought it was funny that they actually showed you a photo that they weren't making it up, because it's definitely a bag full of drugs, ladies and gentlemen. All right, that's all we have for you today. I hope you enjoyed the show. Sorry I missed Friday. I got stuck in a murder preliminary hearing, a little murder for hire. Took all day. My apologies. Tried to make it up with you with bringing you a big, great show today. Anyway, we'll see you tomorrow. Have a wonderful day, and we'll see you next time on Crime Talk. And remember, the Constitution matters.